So welcome back, Business Law and Ethics. We're going to look at Foundations of Business Law in Canada, Chapter 1, Part 2. And first thing we're going to look at is the Charter of Rights and Freedoms, right? So when the Constitution was patriated in 1982, Canada took the opportunity to include the Canadian Charter of Rights and Freedoms in the Constitution Act of 1982. So when they included this, the charter was made the supreme law of the land here in Canada. So the charter proclaims important rights and freedoms of people in Canada, including equality rights, I should say, democratic rights, and fundamental freedoms. So the Charter of Rights and Freedom in the Constitution includes, like I mentioned, the Charter of Rights proclaims important rights and freedoms of people, again, equality rights, democratic rights, and fundamental freedoms. The Charter certainly is a profound and deep impact of the laws here in Canada that stretch from coast to coast, right? So up until 1982, the examination of the constitutionality of legislation by judges was limited to issues of jurisdiction that pertain to sections of the actual law and ensured each level of government had the lawful authority to enact the legislation at the time. So in 1982, everything changed. So Canada is certainly a representative democracy in which people vote for politicians who represent them. If people do not like the laws passed or the policies of the government, the election process provides the opportunity to choose differently in the next election. So very simply, we have a right to vote. And when we do vote, if we don't like what the laws and regulations have been put in place, we can certainly change the government with our vote. This is true, but also take in consideration that there's always going to be something that when it comes to democracy where there's going to be someone that's not going to like something, and it's going to change in the following government, just like the same thing that happened here now in Quebec. Right. So public opinion of the day, the ones in power at a specific period have to respect the charter rights and freedom. Right. So each time a court hears a constitutional challenge about whether a law has violated the charter, the court must consider whether the law imposes a reasonable limit on the right of freedom. That's why it's called the Charter of Rights and Freedom. Only when the court finds on the right of freedom, only when the court finds that the law violates a charter right and cannot be justified as reasonable in its circumstances, will the court strike down the legislations. This is the only time they're actually going to change it. So Canada rights and freedoms are guaranteed by the Charter. However, there are some limits which can be applied, like I just mentioned. So another example is the freedom of expression is protected, but it can be limited by laws regulating advertising, copyrights, hate speech, which we see more and more today, playing a very big part, terrorism, defamation, and noise bylaws, which can play a big part in certain towns and certain cities. So let's look at categories of laws. So this, in addition to recognizing different sources of business law in Canada, it's important to understand key categories into which the law is divided. This enables someone to better understand the function and the purpose of the laws that affect a business or a certain particular business. All laws can be identified as either public or private, right? So substantive law versus procedural law. So if we look at substantive law, it refers to a law that sets out the rights and obligation of individuals. As the name suggests, this is substance, the substance of rules. The substance or substance, same thing, of rules that establish what we can and what we cannot do, right? So substantive law, an example would be speed limit must be observed, exceed an offense, and this violates this substantive rule, okay? Procedural law, right? Rules of procedure create to enforce a substantive law. So this refers to rules that set out how substantive laws will be enforced, right? So in case you speeding, well, procedural law is that you're going to get a ticket, right? There are often numerous rules of procedure on how to enforce a single substantive rule. Example, in the case of exceeding the speed limit, like I mentioned, there may be rules in place that must be followed by the law before someone can be convinced of that offense. So a ticket must be issued. The driver may dispute the ticket. There's a time limit to dispute the ticket. So this is procedural law. So rules governing the court process are also procedural rules. Who will preside at the hearing? How the hearing will be conducted? How witness testimony and other evidence will be admitted? These are just examples of the many procedural rules that must be followed in order to enforce the substantive rule that set out what the driver could and could not do. So the main purpose of procedural law is to ensure a fair process and consistency in the enforcement of substantive law. If you look at the public law, it refers to people as a whole, or the public, I should say, refers to people as a whole, and it's represented by the government, right? So it regulates the relationship between individuals and government at all levels. So the state is also known as the crown, right? Canada is a constitutional monarchy. Monarchy with the queen as a symbolic head of state. Crown is another word used to refer to the state or governments, such as crown lands refer to lands belonging to the government. This is public. Public regulates the relationship between persons, including corporations. Examples: property law, contract, tort law, corporate and commercial law, right? So both terms, right, here, private law and public law and private law or civil law can also be categorized as either public or private, right? So the distinction between the two is foundational and will provide context for understanding how to categorize all the areas of business law addressed, of course, in this chapter. So public law governs the relationship between persons and the state. Private law governs the relationship between persons. The relationship between persons can be personal, social, or business relationships. Government is not a party to the relationship, not a part, I should say, or party to the relationship in private law. Public refers to something that concerns the people as a whole. In the society, the public are represented by the government, like I mentioned before, and public law describes all the areas of law that concern the people as a whole, right? So if you look at terminology, criminal law, defendant can be charged. We have a prosecutor on one side, the judge in the middle, and the defendant. So you have criminal law refers to the rules of the state that are designed to protect society as a whole. So here in Canada, criminal law is regulated by the federal government, which means that criminal offenses are uniformly applicable across the country. This is not provincial. There are a whole bunch of provincial laws that come into play, but when it comes to criminal law, it is federal. So criminal law is enforced by the state, the province, police, and other law enforcement officials have the power to bring charges against offenders. When someone is charged with an offense, the proceeding will be one of the public law. In these legal proceedings, society is represented by the crown attorney, also known as the prosecutor. The prosecutor doesn't represent the victim. His role is to see justice done. So the proceedings in criminal justice systems are about determining whether the accused person, known as defendant, is guilty of the charges. So the victim's role is to be witness in the case. A defendant who is found not guilty, let's say, is acquitted of the charges. The defendant who is found guilty is convicted. Following a conviction, a judge will punish a sentence at the defendant for the crime. That's criminal law. Civil law Lawsuits is different than in public law cases. We do not say that someone is charged with breach of contract or is guilty of tort. We'll talk about that later. It isn't the purpose of laws to punish lawsuits to punish the person sued, so there will be no fines or imprisonment as a result. Categorized as private law, lawsuits involve disputes between persons. A person who has been wronged in private law can sue the person responsible for the harm. So rather than punishing the wrongdoer, the purpose of the lawsuit will be to compensate the person who has been wronged. There is no government involved and thus no prosecutor, plaintiff versus defendant. The person bringing in the lawsuit and making the claim is called the plaintiff. The person being sued is called the defendant. A civil case is concerned with whether the defendant is liable or legally responsible in the matter before the court. If the defendant is found liable, the most common remedy imposed by the court is monetary compensation, also known as damages. The study of business law will most often use this kind of terminology because the law that primarily concerns business falls under the category of private law. Primarily concerns businesses falls under the category of private law. Worth mentioning twice. Burden of proof. Who is responsible to prove the case in court? Right? So we have the trial, which is public law, and burden of proof is the prosecutor. Here, the lawsuit. Who is responsible to prove the case in court? The plaintiff. So the burden of proof lies on the shoulders of the prosecutor or lies on the shoulder of a plaintiff, depending on if it is public law or civil law. And there is a standard of proof where the crime is a higher standard beyond a reasonable doubt, or a lawsuit lower standard balance of probabilities. There was a certain case that came up a few years ago of O.J. Simpson's. It's something that we should look into. If not, you should have a chance to look it up and know a little bit more about O.J. Simpson's case. So the outcome of one case is not dependent on the other, not only because the purposes of the proceedings is different, but because the standard of proof used to establish the facts is different. Standard of proof, again, refers to the degree of proof that must be provided in order to satisfy the court that the allegations are proven. This is the serious nature of the accusation by the state against someone or an individual results in a higher standard of proof in criminal cases. So, in criminal cases, the prosecutor will have to establish the defendant's guilt beyond a reasonable doubt. All right, it has to be done. In the example of a person both charged with fraud in public law and sued in private law, the defendant in the fraud case will be convicted only if the court is satisfied without any reasonable doubt that the crime was committed by the defendant. We also have administrative law, an area of public law that warrants special attention. Refers to the body of law that is concerned with the regulations of business and other activities by government, including the rules created and applied to government agencies and their decision-making powers. It's an area of public law with growing importance to businesses, government also. So administrative agencies are government bodies established by legislation to regulate or foresee a particular activity that requires specialized knowledge. So administrative agencies have three broad functions. Adversary, providing information to help develop government policy; operational, running day-to-day operations; and regulatory. Administrative tribunals. So in some cases, government will use the court to enforce its laws and rules. So, but in many other instances, government establishes other government bodies to help enforce its rules. So whether they are called tribunals, I should say, boards or commissions, these government agencies work alongside the government, the departments, and ministries to enforce regulatory rules. So, an administrative tribunal, is a government body that has a decision-making function. The rules that provide the authority, procedure, and limits to tribunal actions are all part of administrative law. There are countless examples of government bodies that function as tribunals. Right? So, procedural fairness, rules of natural justice, right? So in order to exercise decision-making powers, an administrative body must be authorized to do so by legislation. It must exercise that authority properly and fairly. Circumstances vary depending on the type of administration tribunal, but at a minimum, procedural fairness means that the administrative tribunal must respect the following rules of natural justice. Right? The person affected by the decision must be notified the decision is going to be made. All the information or evidence that will impact the decision must be disclosed to the person it will affect. The person affected by the decision must be provided with an opportunity to address or refute the evidence provided. The decision must be made by the body that hears the evidence. The decision makers must be impartial, free of any bias or conflict or interest in the case. If we look at administrative tribunals versus judicial process, right? Hearing before administrative tribunals differ depending on the type of tribunal and the authorizing statute that created it. Administrative tribunals are similar to courts in the sense that they make binding decisions that affect rights or legal rights, but they are different from the judicial brand of government in some significant ways. Right? So they can take public policy into account when applying the law. Their procedural rules are more informal and flexible. The rules of evidence are much more permissive, such that evidence that would not be admissible in court may be accepted at a hearing before an administrative tribunal. So this is no appeal process that would bring substantive legal matter dealt with by any administrative tribunal into the court system. Right? So the opportunity to involve the court system is limited to challenging whether the administrative body had legal authority to make the decision or whether it properly followed the rules of procedural fairness. This means, or the means of challenging a tribunal decision in this manner in a process known as judicial review. So it's all about challenge. And so you see the word review, you know you're going to challenge. All right, so should a business outsource manufacturing a product to a government where it's legal to use child labor? Should a business recycle even if it is not required to do so? Should a business advertise using images that are degrading to women? So all of these legal principles and ethical values are certainly not the same thing. So to be legal compliant is not enough. Some legal standards are the minimum requirements, and businesses must reflect the moral of its community. So from the perspective of reputation and risk to our business profitability, it may not be enough for the business to be legal compliant. The business may also need to reflect, like I mentioned, and I repeat it again, the moral standards of its community. All right, enough said for the second part. Thank you.